A question that I'm commonly asking myself, and a discussion that's come up in multiple immigration attorney forums that are like secret groups for immigration lawyers to share advice and experience, is should you immediately refile a new I-485 or file an I-290B for a motion to reopen or reconsider? No matter what you choose, I would do it within 30 days. I mean, the letter might say 33 days if it was mailed to you, but I would do it immediately to reduce the chances of being placed into removal proceedings. What should you do if your I-485, which is a green card application, gets denied? This is an emergency situation in 2026 because a denied I-485 is very likely to result in the start of deportation proceedings if you're otherwise out of status. If you have other status, like let's say you've maintained your DACA status, arguably status, or you have like an H-1B for which you are in full compliance and it's not expired, then you're not going to be placed into deportation proceeding. But that's not commonly the situation. If your I-485 gets denied after a marriage-based green card interview and you're out of status because you've overstayed your previous visa, the next thing that's going to happen is a notice to appear in immigration court. And when you get the denial notice, gives you some options at the end of the notice for filing an I-290B for a motion to reopen or a motion to reconsider or both. That form also has options for appeals, so it can be a little bit complicated. And a question that I'm commonly asking myself, and a discussion that's come up in multiple immigration attorney forums that are like secret groups for immigration lawyers to share advice and experience, is should you immediately refile a new I-485 or file an I-290B for a motion to reopen or reconsider? No matter what you choose, I would do it within 30 days. I mean, the letter might say 33 days if it was mailed to you, but I would do it immediately to reduce the chances of being placed into removal proceedings. By the way, even if you refile one or both of these things, you can still be placed into removal proceedings. But in my experience, very recently actually, someone was denied an application, and on day 34, like right outside of the window, they were immediately docketed for immigration court and they received a notice to appear several days later in the mail. When you look up the case, it shows that the day after the 33 days expired, they were immediately placed into removal proceedings. It was filed with the court on that day, which is unusual. Like historically, it could be months or years before someone like that is placed into deportation proceedings. And also historically, a denied green card application usually didn't automatically result in removal proceedings unless there was something aggravating about the situation. Now, the question about whether you should try to reopen or reconsider or just file a new I-485 green card application depends on a lot of things. First of all, was your green card application properly denied? If you filed for your adjustment of status based on a preference category and you were out of status, then it was properly denied. And filing a new I-485 is also going to get denied. In that situation, filing the I-290B might be able to delay initiation of removal proceedings, but I would only do that if you have a good faith argument. My point here is that you're going to end up in removal proceedings pretty much either way. The question is, are you going to do it right away by not filing anything, or like 6 months later by filing an I-290B, which gets denied in 5 months, and then a month after that, you're placed into removal proceedings? If you're in that situation, you need to speak with an immigration attorney to create a long-term strategy, because your clock is ticking. And there's a very high probability, if you're in that exact scenario, that you will have a removal order before Trump ends his term. That depends very heavily on a lot of different variables. Beyond the scope of this video, talk to a lawyer. If you don't know a lawyer, you could always consult with me by clicking the consultation link in the video description below. Now let's look at another scenario where USCIS actually made a mistake and an attorney confirms that they made a mistake and that outcome should not have happened. In that scenario, the question is it better to file the I-290B or immediately refile an I-485? Processing times currently are pretty similar. So the I-290B, the most recent one I filed, was decided in about 5 months. Most I-485 applications based on marriage will result in a green card interview within 4 months. And the green card application costs more than the I-290B. So there's different things to consider. I'm not gonna tell you in this video which one you should file because it's fact specific, and honestly, the same facts 6 months apart, I've given opposing advice depending on exactly what the scenario is and what we're seeing happening with these applications, processing times, filing fees, and the risk that you're actually going to be placed into removal proceedings. But one thing is for sure, if you don't do either of these and you're out of status during the remainder of Trump's presidency, you will almost certainly be placed into deportation proceedings. And from that point, if you don't have a defense available, your clock is ticking. All right, guys, that brings us to the end of today's video. If you need any assistance with an immigration matter, you could always click the link in the video description below to schedule a consultation directly with me. I'm an immigration attorney who handles these cases nationwide. Also, if you're new to my channel and you just want to stay up to date and receive the latest tips and tricks directly from an immigration lawyer who's seeing these things play out on the ground every day, be sure to subscribe to my channel, and I'll see you guys next time for another video.